The International Court of Justice is now in session. President Muhammad Faisal and the Honorable Judges Teresa Florence, Dev Wiriawan, Mediana Indah, dan Ricardo Naibaho presiding. The case before the court is the case concerning the South Yula Ocean and the Mybacovirus outbreak. The applicant and the respondent are each allocated 20 minutes to present their pleadings.
Good afternoon, everyone. Congratulations to both teams for successfully entering the final round. Both the applicant and the respondent have 20 minutes to deliver your claim. First is the applicant. Whenever you're ready, whenever you go, you may proceed.
Good afternoon, Madam President and honorable members of the tribunal. My name is Riyadh Farisi Ramadhani, along with my co-counsel, Nathania. We will be appealing on the present case on behalf of the applicant of the state of ILSA. I will be submitting our first submission in regards to the procedural matter of the case for 10 minutes. And my co-counsel will proceed and submit our third and fourth submissions discussing the substantive issue for another 10 minutes. May it please the court. May I continue, Your Excellencies?
Yes, you may proceed.
Your Excellencies, our first submission would be that Rupta's attack on AHA ship was not based on a thorough inspection. According to paragraph 43 of the case problem, the Rupta Minister of Defense received intelligence information with a photo of an AJF detainee's runway on board AHA ship. But on the contrary, Rupta authorities did not use their full rights to search the suspected vessel, as stated in the Article 31 of the Geneva Convention for the amelioration of the conditions of wounded, sick, and shipwrecked members of armed force at sea. It is stated that parties to the conflict shall have rights to control and search the vessel unilaterally, even employed on board their ships and neutral observers. The lack of a thorough inspection resulted in an attack that violated AHA ship's guarantee of protection, resulted in the death of 30 ILSA military personnel and damages to the ship. Such an attack...
Counsel, I'm sorry to interrupt, but I believe in the case it is stated that the respondent has conducted inspections before conducting the attack, and during that inspection they found the amount of weapons that are in the AHA ship, which then gave them the right to attack, right? So I don't think it is what the respondent did is unjustifiable, don't you think? Because they did the inspection first and then they found the weapons. That's why they committed the attack.
To answer your question, Your Excellencies, may I refer you to the point where, and I quote, a ship member said that the stacks and brims of weapon is necessary to the defense of the ship, and it will only be used as a last resort to defend the ship against possible harm.
Okay, but don't you think that, okay, I'm also quoting the facts in the case, right? It is found that there are racks and racks of wooden containers filled to the brims of racks and racks of wooden containers, and then the weapons were filled to the brim. Don't you think that that amount of weapons are a little bit too excessive for just the mere reason of defense?
Thank you, Your Excellencies. To answer your question, may I refer to the condition that in that time, ILSA and Ruptan themselves are in a status of conflict, but they are on a ceasefire. So in order to defend the ship and to repent attack against possible harm, which later to be proven to be the Ruptan military itself.
Okay, but I apologize for taking a lot of your time, but I'm feeling that what you're saying is a little bit self-contradictory, right? Because you just stated that the state of Al-Zaf and the state of Rupta are right now in a ceasefire, right? So in a ceasefire, there can be no firing of weapons, right? There can not be any usage of weapons. So why does the Ahaship need to carry that much weapons when the Al-Zaf government or even the Ahaship knows that the state of Rupta and the state of Al-Zaf are in a condition of ceasefire?
May I take some time to process your question, Your Excellencies?
Yes, you may.
In the defense of AHA military member by bringing stacks and racks of guns, it is proven that by even bringing that stack of guns, they are not able to defend themselves against the attack of Ruptan military. So in our defense, by bringing the extra weapon, it's not even enough to defend themselves. So yes.
Okay, you may proceed.
Okay, thank you, Your Excellencies. Such an attack, according to Article 51 of Sanrio Manual, can only be conducted if a capture for the suspected AHA ship is feasible to capture, whereas if they use their right, according to explanation before, in all possibilities should be feasible. The second submission would be that the status of AHA ship when it's attacked by the Ruptan military force is still a humanitarian ship and protected by the international law. The Article 21 of Protocol Additional to the Geneva Convention in the section regarding about medical vehicle stated that hospital ships shall be respected and protected at all times and shall not be the object of an attack unless it commits outside of its humanitarian function as a civilian medical units. But contrary to the accusation, a ship only carries the necessary precaution, as I mentioned before, for protection and to be used as a last resort to defend the ship against possible harm. In the aftermath of the attack, it is the result resulted with the death of many Al-Zaf military members instead of the presumed AJF members. The attack on AHA ship also violates the Article 48 of Section 3 in San Remo Manual of International Law applicable to the armed conflicts at sea that clearly states and clearly categorizes AHA ship as a vessel that are to be exempted from attacks and are still applicable when it is attacked by the Ruptan military forces, as it is not proven to breach the conditions that may result to the exemption from attack to cease, and has respected.
If I may stop you there, I would like to ask, referring to your previous argument, you stated that you bringing the guns on board is justifiable. But I would like to ask, do you have any legal basis justifying that a medical vehicle can indeed bring guns on board?
Yes, Your Excellencies, thank you for your question. To answer your question, may I refer you to the Article 22 of the Geneva Convention.
Okay.
It is mentioned that the following conditions shall not be considered as depriving medical units or establishment of the protection granted by Article 19. And one of the conditions is that the personnel of the unit or establishment are armed and that they use their arms in their own defense or in that of the wounded and sick in their charge.
Okay, thank you.
May I continue?
Yes, please.
So, in my conclusion, the Rupta's attack on AHA ship violated the international humanitarian law, as the status of AHA ship when it is attacked by the Ruptan military force is still a humanitarian ship and protected by the international law, and also Rupta's attack on AHA ship was not based on a thorough inspection. Your Excellencies, I've concluded all my submission. If there are no further inquiries, I would like to pass the submission to my co-counsel. Thank you.
Yes, you may proceed.
Thank you, Your Excellency.
Good afternoon, honorable members of the Tribunal. I will be submitting several points in regards to the substantive issue of the case, which will include the third submission that will be Rupta's government failed to notify the other parties, and the fourth submission will be Rupta's government does not wish to cooperate in the prevention of the spread of Mibago virus. Your Excellencies, may I proceed?
Yes, you may.
Thank you. Rupta should be held responsible for the outbreak of Mibago virus, or in alternative, failure to prevent the spread of the disease, and provide compensation for the losses suffered by ILSA. The third submission will be that Rupta's government failed to notify the other parties. Rupta failed to respect the necessity to notify ILSA as other parties or international organizations like World Health Organization with its public health information, as stated in Article 7 of the MIBA Treaty. In the wake of Mibago virus that has met the condition as an event that must be notified in Annex 2.4.2. Meanwhile, Rupta presented no response to the invitation for cooperation from ILSA to address the situation. This violation led to an aftermath of uncontrolled outbreak of Mibago virus.
Sorry to interrupt. I would like to ask, has the ILSA government personally sent a direct invitation of cooperation to the government of Rupta? Yes.
My apologies, Your Excellencies. Can you repeat?
Okay. So you stated that the state of Rupta failed to respond to the invitation of cooperation from the government of ILSA, right? So, did the government of ILSA personally send a direct invitation to the state of Rupta for a cooperation in handling this virus?
Thank you, Your Excellencies. If I might refer you to Article 20 from the Moot problem, it is stated that the state of ILSA have said that they encourage their neighbors, which is Rupta, to do the same, because ILSA, after hearing the information about the Mibago virus, they revoked several licenses provided to commercial hunters and to conduct sanitary testing to ensure that the subsistence farmers are not consuming infected meat. But Rupta presented no response to that invitation.
Okay. You may proceed.
Thank you. The fourth submission will be that Ruptan government does not wish to cooperate in the prevention of the spread of Mibago virus.
So, sorry to interrupt. You said that Rupta did not present no response, but in Moot problem paragraph 23, it is stated that Rupta Ministry Health is in cooperation with international research in taking appropriate measures. How do you respond that?
Thank you, Your Excellencies. May I have a moment to answer your question?
Sure.
Thank you. Your Excellencies, the response from Rupta, we think, was late because before they give that response, stated in Article 22 from the problem, it is said that in early 2015, there was already a lot of cases. The outbreak was already there. If only they give a response a little bit faster, this outbreak may be not happening, Your Excellencies.
Okay, you may proceed.
Counsel, I would like to ask a follow-up question. You mentioned that they gave the response too late. Then, in which convention or in which treaty can I find the span of time that says, oh, this is late, oh, this is not late? Do you have any rules mentioning the time frame?
Thank you, Your Excellencies. May I have some moment to process your question?
Yes, please.
Thank you. Your Excellencies, if I might refer you to Article 7 about notification from the Agreement on the Health and Conservative of the Mibawel, it states that each state party shall notify the other party and organization like World Health Organization within 24 hours of assessment of public health information.
Is it in this article, is it notification or the response?
Thank you, Your Excellencies. I think by responding to the other parties and to World Health Organization, it also means they already notify the other parties. So I think it is counted as notified.
Okay, thank you. You may proceed.
Thank you. According to opening and Article 1 of Agreement on the Health and Conservation of the Mibawel, it is clear that both parties, RUPTA and ILSA, have already agreed to protect, control, and provide sanitary standards to prevent the spread of disease and to manifest their desire to cooperate, promote, and protect the welfare of their people. The European government, on the other hand, consciously ignored the agreement by failing to cooperate when they are invited to take action at the first case of the Mibawel virus. The European government also ignored the invitation of ensuring the sustainability of the Mibawel by ILSA government, which violates Article 5 of Convention on Biodiversity, which later caused the outbreak of Mibawel virus. Honorable members of the Tribunal, we request the Tribunal adjudge and declare that first, that RUPTA's attack on HAA ship violated international humanitarian law, and that is because A. RUPTA's attack on AHA ship was not based on a thorough inspection, and B. The status of HAA ship when it is attacked by RUPTA military force is still a humanitarian ship and protected by the international law. Second, that RUPTA should be held responsible for the outbreak of Mibawel virus, or in alternative, failure to prevent the spread of disease and provide compensation for the losses suffered by ILSA. And that is because A. RUPTA's government failed to notify the other parties, and B. RUPTA government does not wish to cooperate in the prevention of the spread of disease.
Okay, Counsel, just before you end, I would like to ask, do you have any legal basis or conventions or treaties which states that the state of RUPTA should provide compensation for ILSA?
Thank you, Your Excellencies. May I have some moment to process your question? Thank you.
Interruption, sorry. The applicant, your time is running out. You may want to additional time, or you may be proceed.
May I request 3 minutes to conclude my submission?
How about 1 minute?
Yes.
Yes, you may proceed.
Thank you. My apologies, Your Excellencies. I cannot assist you with your question. My apologies, Your Excellencies. I cannot assist you with your question. But we sure that if only Rupta wants to cooperate with ILSA, this outbreak of virus will not be happen. But I don't have a legal basis to answer about that compensation, Your Excellencies.
Okay.
May I proceed?
You may proceed.
Thank you. Your Excellencies, I have concluded all my submission. If there are no further inquiries, I would like to conclude all my submission. Thank you.
Okay, for the respondent team, you may be proceed.
Thank you. Good afternoon, Mr. President and Your Excellencies. My name is Oktadio, along with my co-counsel Rafif, will be appealing on the question on behalf of the respondent, the state of Putra. I will be submitting our first submission in regards to Rupta's justification upon AHA ship attack for 10 minutes. And my co-counsel will proceed with our second submission discussing about Rupta's objection towards ILSA's accusation of mybacovirus for another 10 minutes. May it please the court. Your Excellencies, our first submission will be that Rupta's attack on AHA ship didn't violate the international humanitarian law. The prohibition use of force is justified as self-defense, which regulated by root of jus in bello or international humanitarian law. But personally, Rupta's attack is justified in both grounds. Furthermore, the situation on AHA ship reflects as a threat to use of force against Rupta. Interpretation of Article 2.4 of United Nations Charter justified right of self-defense on the basis of existence on a threat to use of force against state. This is identified by finding demonstration of force, which is considered as a militarized act. Accordingly, the act of ILSA by giving military and logistic supply to Aya Justice Front or LGS reflects as a military act. Yes, President.
Before you go any deeper, could you give us your summary case?
Our summary case? Okay, thank you, Judge. Since our summary case is a dispute between Rupta and ILSA itself, and we are appearing here as the respondent of the ILSA accusation in two aspects, which is one, the ILSA government tell us that Rupta is filed the international humanitarian law for attacking the AHA ship. And secondly, ILSA government claimed the Rupta's government as the outbreak of mybacovirus. So we are here as the respondent to tackle all of this accusation. May I proceed, judges?
And could you show us what is the main problem in this case?
The main problem, well, since ILSA government and Rupta government is in the endlessly dispute for, we can call it as a war, and it is more specifically impacted the ongoing situation while the mybacovirus outbreak is spreading, and also the Rupta's attack on the AHA ship. Is that enough, Mr. President?
And then give us one of the fact that make your client is more higher than your applicant team.
Okay, because we are here as a respondent in the International Court of Justice, we want to prove to all of the people and all of the actors and even all of the parties to prove that Rupta's government is not responsible for one, for the outbreak of mybacovirus, and secondly, we are not responsible and we are not violating the international humanitarian law for attacking the ILSA AHA ship. Is that enough, Mr. President?
You may proceed.
Okay, thank you. This is identified by finding.
Sorry for interrupt.
Okay.
I do want to ask a question. You stated that it was a self-defense mechanism done by your country. What I'm curious is, does self-defense is permissible under international law in regards international humanitarian law, and is there any kind of threshold to be fulfilled before any state doing self-defense mechanism?
Okay, thank you, judges. I understand your concern. Since we, the respondent from RUPTA, deciding this case as a self-defense, it's caused by some several reasons. One of them is that ASAF government sends their AFF ship into RUPTA's territory with the military personnel and also with the military weapons. So we, as the government of RUPTA, feels that it treats us as our sovereignty. May I proceed, judges?
Yes, you may.
Okay, thank you. Moreover, this is suffice to be established as perceived armed attack towards RUPTA under accumulation of event facts. Therefore, attack on AFF is justified as a self-defense against threat of use of force. Second, RUPTA's attack in accordance of rules of international humanitarian law. International armed attack or armed conflict, or IAC, is defined as armed conflict which may arise between two or more states. The involvement of states could be deduced by finding indirect intervention through all of control with two criteria. One, the provision of financial and training assistance, military equipment, and operational support. And second, participation in organization, coordination or planning of military operations. Accordingly, this requirement has already satisfied. Therefore, any conduct must be based on the principle of the international humanitarian law for aiming for military objectives. However,
sorry to interrupt.
Okay, David.
However, in the Geneva Convention, it is stated that there are civilian objects, right? Objects that are not allowed to be attacked during a state of war, such as hospitals, homes. So in this case, the EHA ship can be considered as a hospital because it is a hospital ship, which makes it a civilian object, which cannot be attacked during, an armed conflict or even a non-international armed conflict. So how is the attack conducted by the state of RUPTA justifiable? That the attack on the EHA ship by RUPTA is justifiable? How is that?
Okay, thank you, Jadis, for your concern. I understand it. Since the hospital ship is a self-claim by ILSA government, but we as the respondent of RUPTA's government believe that a hospital ship doesn't have to include any armored weapon and military personnel inside of it. That's why we as the respondent in RUPTA's government can conclude that this ship is not a hospital ship, but it is a military act of ILSA government. Is that enough? May I proceed, Jadis?
You may proceed.
Okay, we are concluding that okay.
If I may interrupt you, I would like to ask two questions. So firstly, the applicant said that under Article 22 of the Geneva Convention, a hospital ship can carry guns. But then you said a hospital ship should not be provided with guns. But what is your legal basis to your statement? And then secondly, I would like to ask, if I'm not mistaken, under Article 51.2 of UN Charter, I might be wrong in the article, but before a use of force, a state must first notify the Security Council. But I noticed that the respondent haven't fulfilled the requirements yet, that requirement. So do you think you're still justified to use of force?
Okay, thank you, judges. I understand your concern. For the first question, why this ship is we feel like this is violent and trading us. Since previously from the applicant statement, the judges also believe that we are between ILSA government and RUPTA government are in the ceasefire. That's why we are not allowed any weaponized weapons and any military personnel that through our territory in RUPTA. And secondly, the ILSA government has already committed that their ship is a hospitalized ship that needs and access to save the refugees from Zahrani. We believe that the ILSA government that want to save the Zatonika people, they are going to through our territory in Rupta. But that cannot be justified that the ship itself is containing weapons and military personnel. And the second question about, according to Article 51 United Nations Charter, we believe. Sorry. Yeah, is there any interruption?
Okay, maybe one last question.
Oh yeah.
So you're saying that bringing weapons is not allowed, but you attacking is okay, even though it's in ceasefire?
Okay, first thing first, may I have another 2 minutes to answer the question from the Judge Florence?
Yes. The respondent, your time is running up.
Yeah. May I have another 2 minutes?
Yes.
It's 1 minute. How about 1 minute?
Is it okay? Since we haven't tell about our memorial yet, since there are a lot of questions, is it allowed for 2 minutes?
Okay, you maybe proceed the answer, or you maybe turn up in your conclusion or something.
Okay, that's okay. Okay, so it will be 1 minute for the extra time?
Yes.
Okay.
Okay,
Just
to clarify the question from Judge Florence. So I think what she's trying to say is, I think what your statement is quite self-contradictory, because you said that in a state of ceasefire, you're not allowed to bring weapons. However, you're the one who conducted the attack on the airship. So there's a little bit of self-contradiction in your statement. So can you clarify to us what you meant by that?
Okay, thank you, JJ. I understand your concern. First thing first, the ILSA government, it's not the first time send their ASA ship to the Rupta territory. The first one, we noticed that the ASA ship is containing the weapon and the military personnel for the first time. Then we tell the ILSA government, and the ILSA government itself doesn't do anything. And the second time, we still found that the ASA ship is containing weapons and also the military personnel. That's why it threatens our sovereignty. So it cannot be justified that we are attacking the other ship and we call it as a militarized weapon. But we know that this is self-defense, since the ASA ship is a military objective, so we have the right to attack the ASA ship itself. Thank you. If there are no any inquiries, my second co-counsel will tell the audience here about the second submission. Thank you.
Thank you. You may be proceed.
Okay, thank you, Mr. President. Good afternoon, honorable members of the tribunal. I will submitting several points in regards to the South Ocean and the Meliala virus outbreak, which will include the second submission. Your Excellencies, may I proceed?
Yes, please.
Okay. Thank you, Mr. President. Okay. Rupta is not responsible for the outbreak of the Meliala virus, which also is liable for the losses suffered by ILSA. The Meliala virus outbreak was suspected to be contributed by the Athena corporate's actions. While the corporate was incorporated in Rupta, it holds no affiliation between them. Thus, Athena's acts cannot be attributable to Rupta. Rupta has fulfilled its obligation in a good faith. Thus, Rupta holds no responsibility to compensate ILSA. There are 5 points that shows that Rupta is not responsible for this case. Firstly, Athena's conduct is not attributable to Rupta. A private entity may be attributed as state's responsibility if it exercises a governmental authority granted through internal law. Athena's conduct is not attributable to Rupta, since Athena is not directed nor controlled by Rupta. And it
also, before you proceed, I just want to ask, but it is a known customary international law where states are obliged to ensure the international public health, right? So,
Yes.
and in this case, there was an outbreak, and it started in the state of Rupta. But just now you said that it was that Rupta should not be responsible for the outbreak because it was a conduct by Athena, a private company. So,
Yes.
how do you justify yourself? Because right now, as a state, you are obliged to ensure the international public health. However, so how are you not obliged to do that at this point? So why are you blaming it on Athena?
Okay. So, thank you for the question, Your Excellencies. May I show you the second points? The second points that Athena is not controlled by Rupta itself or the government authority. So, Athena have to fulfill two aspects. One of them is a functional test and a structural. Now, functional test is required to Athena. It has to be a commercial nature and governmental authority. And the second one, structural. To be exact, Rupta is just having a capital ownership, just about 30%. There's no stakeholders. That 51% is it is not fulfill the government authority before after the capital ownership is going to be a 51%. That's all.
But
So
however,
Athena,
in the case, it is also stated that the government of ILSA, the government of Rupta also provides subsidies, right, for Athena. So, so are those subsidies not considered as an act of governmental authority over that private entity?
thank you for the question. My apologies. Can you please repeat the question?
Okay.
Excellent.
So, but in the present case, okay, you stated that the government only has 20% of the stakeholders, right? And it's not
30.
enough to be 30. Okay, 30%,
Yes.
and it's not enough to be an owner of that company,
Yes.
right? However, in the present case, it is also stated that the government of Rupta contributes and gives subsidies for the company of Athena. So are those subsidies not considered as a form of an act of governmental authority to that company?
Okay. Rupta itself is not conducting Athena's or directing or controlling Athena's by Rupta. So I'll explain you like this. Governmental authority is just like a responsibility between Athena and Rupta. Okay. So Athena acts independently presently. Athena acts independently. So it's reflected by its independent response to discovery of Meliala virus itself. So there's no government authority that has to be taken down to Athena like that. Your Excellencies.
Okay, you may proceed.
Okay, thank you, Your Excellencies. Point 3, okay. Athena does not satisfy the necessary elements of government authority. A private entity is attributable to the state if it is not proven to exercise a governmental authority. Whether an entity exercises a governmental authority or not is determined through functional tests and structure, which are not satisfied by Athena. And fourthly, Rupta has fulfilled its obligation in good faith. Parties of MIBA treaty are obliged to send notification and consultation when public health events occur. In performing treaty obligation, states shall perform in good faith. Compliance may be reflected in the form of effort in performing its obligation through good faith. In the present case, Rupta has complied in good faith through its effort and readiness to cooperate with ILSA, as well as contributing through national research in regards to the outbreak. Therefore, Rupta has fulfilled its obligation in good faith. And the last one for the fifth point, Rupta holds a responsibility to compensate the ILSA losses because Rupta doesn't conduct any internationally wrongful acts, as Athena's conduct is not attributable to Rupta. and Rupta has fulfilled its obligation. Honorable members of the tribunal, we request that the tribunal adjust and declare that Rupta's attack on AHA ship did not violate international humanitarian law, alias IHL, and declare that Rupta is not responsible for the outbreak of the Meliala virus, thus is not liable for the losses suffered by ILSA. Thank you, Mr. President and Your Excellencies.
Thank you for its team to deliver your argument or your claimant in the final round. You are already do the best. Maybe the other judge have some feedback for all of you.
Maybe the president would like to start first.
Yes, you proceed.
Okay, so for both teams, congratulations. You did a good job. Ini informal aja ya. Both agent dari applicant and respondent are very good since it is the final, and they were able to present their submission with a very good structure. Jadi kalau balik lagi, kalau misalkan berargumen kan harus ada structure, kayak kalau misalkan dalam IMCC itu IRAC, jadi they can istilahnya understandable gitu loh, maksudnya gampang dimengerti dengan structure yang ada itu. Terus kalau misalkan untuk feedback dari applicant ya, I noticed there were a lot of time kayak they took too long untuk nyari legal basisnya kan. Tapi it's fine, mungkin due to lack of research sebenarnya nggak masalah. Cuman kalau bisa, kalau misalkan nanti ikut IMCC lagi, please do understand atau istilahnya apal mati facts dan laws-nya. Jadi saat kalian ditanyain sama judge-nya, ya kalian udah siap gitu loh beforehand gitu. But overall bagus. Terus untuk second speaker dari applicant itu tadi terakhir kalau nggak salah ngomong tentang conclude their submission, tapi there were no conclusion was conveyed gitu, jadi nungguin gitu, jadi kayak nanggung. Terus untuk ya overall untuk semuanya oralistnya great composure when answering question. Soalnya banyak kalau misalkan istilahnya ya muters yang baru pertama kali ikut IMCC starter kalau misalkan mereka answer question from judges, but I see none from both oralist, jadi well done.
Okay, thank you for the feedback, Judge Ricardo. Maybe the other judges have any feedback.
Maybe starting from Day for me first.
Okay, I'll go then. First, of course, again, first of all, big congratulations for both teams for getting into the final. And yeah, a few feedback aja dikit enggak. I kind of agree with what Ricardo said. Kayak tadi the applicant especially, they kind of took too long in searching their legal basis, jadi itu kayak makan banyak waktu. But yeah, itu again, it's totally fine. Apalagi kayak it's your first time, terus kayak tadi kan I think we can consider that session as a hot bench where the judges just kept asking questions and asking questions after questions after questions. And also I also agree with Ricardo where you actually kept your composure. Jadi kayak nggak stutter, nggak tiba-tiba diam kayak gitu. But you took your time to say kayak, oh, your excellencies may have a moment to answer your question atau kayak gitu. It was great. And then I really appreciate how you kept your composure, tetap tenang. And then big props juga for the first agent of the applicant. You were able to actually deliver us a lot of legal basis on your arguments, and it is very good karena akhirnya when you were answering the judges' questions, your answers were not baseless. Okay? There is a base on your argument, and it really helps to convince the judges a lot. And Second applicant juga bagus. You were very composed. You managed your time pretty well. Cuma memang tadi yang terakhir when you were about to conclude, I think you forgot to conclude. Jadi kayak there was kayak this moment of pause. I think it's fine. We got what you were arguing about. And for first respondent, yeah, it's kind of normal in an IMCC where you're not able to present all of your arguments because due to the amount of questions that the judges ask, and itu memang sometimes it can really happen. And tapi what I really appreciated about your performance was you still kept your composure itu. You still tried your best to answer the judges' question, and you also tried to conclude your submissions as efficient as possible. Regardless, walaupun waktumu tadi sedikit kan. And last respondent juga bagus. You managed your time well. And you manage your structure juga bagus, and you delivered all of your points to the judges. Yeah, that's all for me. Yeah, again, great job for both teams.
Thank you, Judge Dave. Now maybe Judge Florence will give any feedback.
Okay. I would like to congratulate the advancing teams for being very good today. I mean, you guys did amazing. I think all of the judges and many of us were amazed by how much you guys are able to, do so good even though this is your first experience. And then maybe I would like to give only a few points because I agree with what everything Judge Dave and also Judge Cardo said. I would like to state that when you are giving your arguments, please always bring out your legal basis. Giving out a lot of arguments or statements, but without any base doesn't mean anything. The point of legal moot courts are always in the legal basis. So always provide your arguments with convention, treaties, or any types of sources of law because it's very important and very fundamental. And then maybe make sure that when referring to judges or referring to your arguments, use the appropriate choices of words. For example, I heard someone said, okay, while talking to a judge. You're not supposed to say okay to a judge or ask them, this is my legal basis, okay? No. When referring to a judge, always refer to them with demeanor and also with good, how do you say this? Pokoknya dengan kesopanan gitu. The judge will rule your issue, so always make sure that you use the appropriate choice of word. And then rather than saying, I will continue on to our fourth, fifth, sixth, try doing, we would like to submit, and on our next submission, or just try on various, types of
simple words.
Yeah, simple words, or you can try out a lot of words rather than just first, fourth, that. Okay, I think maybe that is all from me. I think you guys did a great job, and I look forward to you guys joining IMCCs.
Thanks for Judge Florence as a feedback, and then maybe next Judge Mediana have other feedback.
Okay, first of all, I would like to say congratulations guys for both teams making to the final round, and I would like to give overall feedbacks. I think you all guys have well-structured arguments and points, but you have to be more elaborate further on the legal basis that you are really relying on, and how those legal basis support your arguments, and how they also apply to the facts of the case you are mentioning. Thank you.
Thanks for all of the judges as the feedbacks. I think you already have a good job, but I think some of the feedback has been conferred by other judges, and I just will say the addition of the feedback. For the applicant versus oralist, for Riyadh, I think you are already good, have eye contact, but not really eye contact. I think you read the text or the script a little bit, and you have a good time management and also capable answer question by faster. And for the second application, for the Nathania, and you're already good too, but unfortunately you lack of time management. But this is very important for time management. And then you are capable answer, but I think you are slowly. I think like you should know what is the case and what is the question, and you can take a notes in your mood problem or in your script, and can help you to answer very faster. You already have eye contact, and you are not with the script too much. For the first respondent, Oktadio, you are already good too, and you have a good eye contact and very interactive. You really like not read at all, and then you already have a good answer. You already fast to answer the question, but you should improve time management. And then you're good in the material so that you can answer on the, and you not really read the script. For the second oralist, respondent, Daffa, you're very calm, which means this is a very good, and you have a good time management. So I think please speak more louder than before, because your sound is like a little bit not really louder. And then you have please improve your interactive eye contact to the judges. You already good in material, but you may be better if you have a good intonation for deliver your argument. I think that's my argument. To the next, I will invite the bailiff to continue lead the next event. Thank you. Congratulations to both of them.